Please have a seat. I will call the case of Jacob Daniel Pullen versus State of Texas, 0424713CR. Announcements?
Good morning, Jesse Ford for Appellant Pullen.
Chris Eaton for the State of Texas, Guadalupe County.
Thank you. Are you reserving any time for rebuttal?
I believe, according to the notice, I think I get 10 minutes,
10
so I
minutes.
was going to follow the allotments that the court provided.
Great, please proceed.
Yes, ma'am. Good morning, again, Jesse Freud for Appellant Pullen, and may it please the court. This is a sufficiency case. Alternatively, it's a confrontation case. For these reasons, I'd like to open argument by focusing on points of error 1 and 4 of our brief. And then in rebuttal, my plan is to respond to any important points that the state makes and a couple of the smaller issues. But I really want to focus on sufficiency first, not only because it entitles my client to the greatest relief, but also because I think this case just screams really unique sufficiency issues. And hopefully that's one of the reasons why we're here. Before I do that, I do want to note 2 small corrections to our brief. On page 9 of our reply, I cited to 4326A1. I didn't realize that the statute had been updated between briefing. The content of the site is correct, but the A1 is not, so forgive me for that. Secondly, page 20 of our opening brief, it states that State's Exhibit 5 was the client's interview from before his arrest. That's wrong. It's from before he went to jail. The interview is from just after his arrest. So I just wanted to fix those 2 points. And then unless the court tells me it's not necessary, I felt like a factual recitation may be helpful here, but if it's not necessary, I'll dive right in.
I would move into your issues.
Yes, ma'am. So sufficiency. I think the easiest way for the court to come to a decision on sufficiency is on the issue of whether or not the collage was on the website on the date of access. I think that avoids some of the more complicated issues that follow. And so I think I'm asking you what's the easiest way to a reversal, or excuse me, a judgment of acquittal for my client. I think it's on the issue that was most heavily litigated at trial, which was, is this collage on the website? And I will note here, it is not in the briefing, but when Mr. Eaton and I were reviewing the exhibits before we started this morning, my mind is blown. Looking at States 1 and 2, they're under seal, so I can't put them up for you, but States 1 is supposed to be the top of the webpage, where it has the name of the site and the indicator that Agent Croft, I believe, describes as a graphic indicator that this is a CP site. State's Exhibit 2 is supposed to be the membership options, followed by the collage at issue. This isn't mentioned anywhere, and again, this really just came to our attention this morning, but if you look at the domain names, again, I appreciate they're different than traditional domain names, but if you look in those fields, States Exhibit 1 has a registration.html. States Exhibit 2 has a signup.html. So even though I think, again, it was very clear from the record that the consensus in the testimony is nobody can say this advertisement is on this site on the date that he supposedly visited it. But I think what this new observation as to these exhibits points out is it's not even really clear.
Was that litigated, though? Was that ever brought up in trial?
No, ma'am, it wasn't. It wasn't. My mind was blown. I was really surprised by that. But I think that is an additional consideration. When you're looking at these exhibits, they were in evidence. Who knows what the jury may have paid attention to, but...
Was there any evidence offered by the defendant that he actually did not see those images, or that was not the landing page that he was on?
Yes, ma'am, he was very clear. He didn't see anything that was a photograph in nature of any kind. CP, or otherwise. I think the heart of his testimony that really explains what he was doing, and his testimony does get confusing at parts. And I think one of the reasons is because the vague term website seems to be convoluted at many points with, are we talking about the hidden wiki, or are we talking about clicks that took you outside of that? And I think that's really unclear. But he is very consistent. I didn't see anything. And he didn't even remember which sites, because he talks about going through multiple of these indexes and says, I don't even remember which ones opened, which ones didn't. So I think the record is really clear that he never admits to seeing anything. From there, I will say on the issue of Ranger Evans' testimony, it is completely without any kind of factual basis, and the few points where he is asked about his knowledge of contents of the site, he consistently says, I've never been to the dark web, I'm only relying on what HSI told me was on there. And so I think the three cases that really help you eliminate the ability to support the verdicts based on his testimony are Baltimore. In Baltimore, which we cited in our brief, it's a 2023 case out of the CCA. It talks about the Curley case. And between Baltimore and Curley, what those cases say is no matter how many times in the record somebody may make essentially a conclusory, unsupported statement, that can't by itself support a verdict, because juries are allowed to make reasonable inferences, but they're not allowed to speculate. And so I think that completely takes Ranger Evans' testimony out of the equation for you. What I also think takes this issue out of the equation for you is this concept of what is a reasonable inference for the site changing? How much time is too much time? And again, hopefully one of the reasons we're here is because I think this case has some broader implications about what is the necessary proof for what you can prove is on the internet at a particular point in time. And I think that's really relevant to the way our laws controlling computer crimes are handled. And I think this is a really great example of the internet changes all the time. And there is nothing in the record that reasonably supports an inference that because HSI saw what they claim they saw on the splash page on July 8th, and there is nothing in the record that talks about a subsequent visit to the site. I know in the state's brief, they mention that the investigation itself can support an inference that it was there. But when you really go and drill down on what's the length of the investigation, how many times did HSI visit the site, there's really nothing there. I think a reasonable inference from Agent Garcia's testimony is they only did this on one day. So even if the investigation continued thereafter, because there was talk about serving subpoenas and doing some other administrative work, that doesn't mean that anybody visited the site multiple times to say, hey, we had a 30-day investigation and we visited the site 3 times over those 30 days and it's clear that it didn't change. There's nothing.
So you're saying the record doesn't make it clear how long the investigation was? I thought they testified that the landing page hadn't changed throughout the investigation.
Yes, ma'am. That's what's, I think, an unreasonable inference to draw from the blanket statement, our investigation. There's no context to the amount of time, and the little bit of context we do have is that really the majority of the work that was done to locate the site and then visit it was a day task. I don't think there's anything that suggests it was longer. There is, I think, an exhibit or two that are subpoenas that may have been served by HSI, but there's nothing in the record from any of our 4, what I call our New York witnesses. So our first 4 states witnesses are all of the HSI New York agents. There's nothing from any of the 4 of them that talk about the investigation was this length, or anything that you can infer, this is when it started, this is where it ended, and this is how many times we visited. I don't see anything that lets you make that leap. And in contrast, the only thing you...
Ms. Freud, in this
Yes, ma'am.
case, your client testified.
Yes, ma'am.
On the sufficiency evaluation, isn't it possible the jury didn't buy his explanation of how he started to indiscriminately click on links, and they could have just said, we don't believe that, and found enough evidence? Isn't that correct?
Yes, ma'am. The jury is obviously free to believe some, all, or none of any witness's testimony. That's absolutely true. And they can, of course, make negative inferences from that, but there is still nothing independent of that to support that the collage was on the site, or anything I think that would constitute a reasonable inference that he visited it with the intent to view the site.
So wouldn't we create a problem, since on the dark web you don't have the sort of cache or cookies that you have outside of it? So if we did what you want, the investigation would have to show what the landing page was on the day that he accessed it, meaning in these cases it would be very difficult to ever prosecute someone.
I disagree respectfully, and here's why. There are a lot of ways you could maybe circumstantially infer. Cache doesn't have to be the only one, although I will say, I think the testimony saying that it is impossible to get any kind of search history from Tor, while I appreciate that was the message that was trying to be communicated, I think if you really go back and look at that testimony, it was hedged at a lot of points, because that's just not totally accurate. I also think from looking at the few cases we do have on Access, so many of them actually result in some other activity that allows you to make an inference. We don't have any of that here.
Like give me an example of what would have had to have been proven in this case.
So the payment is what is really the evidence of intent, right? No payment, no case. So the payment, though, doesn't prove access. The payment could arguably prove maybe another offense. I reread the bill of exception that trial counsel made while the jury was out deliberating punishment, and it was in response to the argument being made that Ranger Evans, y'all can know that that collage was on the website because Ranger Evans told you it was, and trial counsel, I think, did a really great job of putting the reports in the record that shows he didn't know that, but notably, to answer your question, Justice, is that there was a related case out of Atlanta involving another person who was in a position of public trust. I'll use his initials, RT. He was only charged, and I appreciate there can be reasons, discretion, being in federal court, he apparently was in the Air Force, so I know there can be maybe a variety of explanations, but he was only charged with one instance of attempted possession for the same conduct. And I felt like that was really interesting. And so I can, based on that, conceive maybe the payment would have supported probable cause for attempted possession. I have a feeling the reason that that wasn't done, again, perhaps the federal and state jurisdiction issue is because, like Agent Garcia said, teen category, whether we like it or not, by itself isn't illegal. It's just not. If we want to make it illegal, we got to go ask the legislature, and then we don't have this ambiguity where you're saying this is a prohibited set of material based on this ambiguous category. So
I want to take you back before we're getting this straight, because the point that you brought up, the issue of importance is the evidentiary point of what has to be in the evidence to prove that somebody actually accessed the landing page that is the exhibit, right? And so what I'm asking you is, are you saying that there would have to be evidence that on that day the landing page was what the exhibit was? I'm trying to get, where would the line be for you? What would you want us to rule?
I think if there had been actual testimony that we had a 30-day investigation and we checked that site whatever y'all want to deem as a reasonable number of times over that period, and evidence of that nature, that the website wasn't changing and that it's static. We have some other, so that is my answer to your question, is,
You're saying in this case, we don't know how long the investigation was, there wasn't evidence that they continually checked it, et cetera.
correct, yes, ma'am. And the other evidence that we do have is that the site was changing in some really material ways. I think the site is 10RR62. I'll double check that when I sit down. If I'm wrong, I'll tell you. But where Agent Garcia says the BTC address changed, and she says one other thing changed. Maybe it was the wallet address. So she said two things changed. And then on redirect, the prosecutor asked her, but not the pictures. And I think the answer she gives is a little misleading because there's nothing that says that there was a subsequent check. And I think that's why her answer hedged a little. If you're only on the site once and you're saying, I had a one-day investigation, was on the site once, yeah, it never changed during the one day. I'm not sure that that can reasonably support the position that the investigation's length or implied length means we had a static website with an advertisement that we know was there a week earlier.
Can you walk us through, you also have a request that this be deemed one image, not one crime, not 7 crimes. Can you walk us through that reasoning?
Yes, ma'am. So I know we have a couple cases, I think Vineyard is one and Witt is another one, saying every image can support a separate count. But I think what we have here is we have one image with just multiple components. I think the statute and a lot of the cases that talk about unit of material justifying multiple counts are photos, books, not a single image collage with multiple parts. And I think the additional problem that presents is you have to access with intent to view. So you have, that's why in my brief, and I have to give trial counsel credit for this, when she was explaining it to me, she's like, eyeballs gotta be on it. You gotta wanna put your eyeballs on the image. And here I just don't see how you make that distinction, where in other cases where the issue of units of material justifying each count are very clear. It's multiple images, film, books, and I don't think we have that here. I think we have one little graphic with 7 sub parts in it, and I don't think that that justifies setting it up into 7 different images. And then the complication, if you do, that presents, how do you, there's no evidence that they can show that he looked at every one of those images. So I think and it's an advertisement, right? The point of an advertisement is to just get somebody to look at one thing, not multiple things. So for those reasons, I think to separate a collage out into multiple parts units to justify multiple counts is not appropriate. And so I'd ask that
What if the collage was 1,000 images? I mean, you still think it's one image?
I think size matters. I think location matters. 1,000 images that are, that little, is that even really something you can look at? So I do think it's case by case, but I think a part of the intent to view is the material has to be actually viewable. And if we have an ad of this size and we're putting, 1,000 parts in it, is that something that anybody's reasonably viewing anymore? I don't think so. If there's no more questions on the topic of should we consider the collage one or multiple sections, I think let's talk about intent, because if the court doesn't like the analysis that I've provided on Do we know that the collage is on the website? I think the next big question is intent. And what does the payment really prove? I think we've talked about that a little bit. But I think the important things to note here are there is no testimony that said with any kind of certainty that he made the payment that the payment proves he went to the site, that he actually accessed the site. What his test talks about, now I know what they're saying because I've seen the discovery in my case, but nothing from him said, yeah, I know I went to the site. So for those reasons, I don't think that the payment proves what the state tries to say it proves. And then I'll save the little sub-challenges to the individual accounts for rebuttal, but I think maybe the next topic to transition to is, oh, I'm out of time,
We'll see you in your rebuttal.
Oh, okay. I could keep going all day.
Thank you.
Excuse me. All right. Your Honors, I'm just going to go ahead and just dive right in, and I'm going to, just like defense counsel here did, I'm going to focus predominantly just on the issues that she brought up. Just in related to the exhibits we had looked at this morning, as Your Honors noted that, no, the issue is not litigated in any capacity. Moreover, as far as why there'd be a distinction, no witness was asked about it, just to the extent it just simply was never discussed by any witnesses or litigated by the parties.
But you don't disagree the juries had the exhibit?
Yes, the juries had the exhibits to look at for themselves. As far as the investigation, I want to spend quite a bit of time with this. So defense is correct in that what Garcia testified to is that, right, the images did not change over the course of the investigation. And she's also correct that Garcia never specifically says, I investigated for X number of days. But there's a lot of context clues that suggest that would have allowed the jury to reasonably infer that the images were in fact static. The turnaround time in of itself is not particularly long. So Mr. Pullen's transaction, I believe, was July 2nd, whereas the day that the feds lay eyes on the site for the first time is July 8th. So we're not talking about like weeks, months, years, it's 6 days. The second
So what is the evidence that the jury had that proved beyond a reasonable doubt the elements of the crime, that on the second or whenever the Bitcoin transaction was, that those images were on the page? It's
from Garcia's testimony that, where it dovetails also with Investigator Croft and a little bit with Joey Evans. In the case of Croft, he talks about in his testimony, both in direct and cross, that they went back to go do a test buy. Believe that was July 10th. So to have conducted a test buy meant that Garcia's co-investigator, Joshua Croft, had to have gone back on the 10th. So at that point, you've got Garcia laying eyes on the 8th, at a minimum, Croft himself going back on the 10th. So at the very least, that the investigation would have had to last those 3 days. But beyond that, you can look at what Garcia says she did. So they went to the site, they had a blockchain analysis conducted, they had to go issue subpoenas to, I believe it was AT&T. I think she said she had system with Coinbase and then with BitPay. And then so to do that, you have to draft the subpoena, issue the subpoena, get the return from it. And she learned information that allowed her to tie the Bitcoin transaction that was found back to Appellate. So you're then having to then process that information. On top of that, she talks about investigating, at least a brief investigation of who Appellate was before ultimately turning it over. So what you know from Evans, so he gets it based on Davis Brothers' testimony, he gets it maybe September, October, I think is when Davis Brothers said he transferred it over to Ranger Evans. Ranger Evans goes and issues his own subpoenas as well. I think one of them was also to AT&T. So he talks briefly about, well, sometimes you have to wait a week or two for those to come back. And the reason why that testimony matters in this sense is so the jury can infer, well, if it's taking him, a few days, a week, whatever the case may be, to get returns on his subpoenas, and she's issuing subpoenas likewise to similar companies, that it's fair to conclude that she's probably experiencing the same thing. So with all the activities she conducts over the course of the investigation, I think the jury can reasonably infer that it's not just like she's there, that this takes place one day and she's done and she passes it off. And then again, to be able to conduct a test buy, the only way that I could conceivably think to do that is to go back.
And was there any evidence that they went back in September or October?
No, Your Honor.
So nothing after like the week or two after the
No,
incident?
once it's transferred from HSI in New York over to San Antonio and then to the Texas Rangers, right, Ranger Evans does talk about knowing what was on before and what was on after, but is ultimately never asked why, what was the basis of that conclusion. But yeah, neither him nor Davis Brothers mentioned going back to the site. The main witness who does is Joshua Croft. And then I also want to talk just briefly a little bit about the collages themselves, because Your Honors had asked defense about 1 versus 7.
And I'm sorry, Mr. Eaton, I don't want to.
I apologize.
You don't dispute that there's no direct evidence of
Correct.
what the landing page looked like on July 2nd? Or
Correct.
There's
No, I
direct
do
evidence.
not. And actually, before I attempted to segue, that brings up something else I did want to discuss, is that this ultimately what they did is an investigation. So typically, what an investigation would be designed to do is it's usually you're investigating the commission of crime after it's happened. I mean, we can't go in and, Jason Bourne and predict before it happens. So you're having to
You find child porn, right, on devices, right? And in this case, there was 0 child porn.
Correct. This is a purely access case. So what he's charged with doing is accessing that landing page that had the images on it, and those are the seven images. So yeah, the state would concede there was on all the devices that they seized, they did not find any child porn. What they found was the Tor browser on a couple of his devices. They found the BDR app that was used to make the transaction on his devices, and then information from the BDR app. But no, he had downloaded nothing to the devices themselves.
So it seems like the central point is what did he see on July 2nd?
Correct.
And there's no direct evidence, and we're relying upon a reasonable inference that the jury could make. So what would lead them to make that reasonable inference?
I think based on what Garcia's testimony was about how the site behaved. So, right, so the federal government would have seen it on the 8th. So with it in their hands, so we know, again, at least for the 3 days, based on her testimony combined with Joshua Croft's testimony, that the jury could reasonably infer that at least it's not something that's changing every hour or every day. Because if he went back to go do the test buy 3 days later, and she's saying, well, it hadn't changed as part of the investigation, I think the jury can then reasonably conclude, well, at least over that time frame, nothing is changing. So you can extrapolate from that. Well, if it's not changing when it's in their hands, the jury can reasonably conclude it wasn't doing it before,
So
absent.
you're just saying the fact that it didn't change over 3 days, 2 weeks after the incident is enough for a reasonable inference that on the day that was there?
Correct. Well, because it wasn't 2 weeks after the incident, so the
6 days after the incident.
correct. And it's not just the 3 days. I think that's the crux that they can say that, we know definitively it's not changing. But that's why it goes beyond that. When you look at what she does, if it's not changed over the course, what she does over the course of the investigation, I think it's up to the jury ultimately what they want to credit for her testimony as far as whether she checked on it or not, because
Well, that's what I'm asking. Is there any evidence that they checked on it after that 3 days?
No, Your Honor.
So you're really relying upon what they did over 3 days' time?
Correct. But in this case, I think that is enough to support the deduction, because so we're talking about if it's not changing over the course of those 3 days, there's nothing that says that the images are changing, particularly since there's also evidence that the wallet app was changing over that time frame, that a jury could reasonably conclude, well, it's not doing it now. We don't have any additional evidence to suggest that the behavior of the website meaningfully changed either from either side after that
It's
point.
not whether they present evidence defeating your point, it's whether you presented enough evidence to make it.
And I think that does that in this case, because I think that again supports the deduction that if it's not changing, for
If they
us.
checked in September or October and the website had been changed, would that have defeated your claim?
I don't think so over a time frame that broad, and I think the relatively short time frame between discovery and transaction is important here. So yeah, I think if the time frame between discovery and transaction had been, pushing 2 weeks, 3 weeks, a month, the longer that stretches, I would agree that starts pulling it apart some, so that if they didn't check it in 3 or 4 months later, that would be more of a problem. But since they caught it within 6 days, and they're not seeing evidence themselves that it's constantly changing for them, they could reasonably conclude that it wasn't doing it before.
It didn't change over 3 days.
Correct. And so that the jury could say, well, if it's behaving this way over the time frame we do have, it's reasonable to extrapolate that it wasn't doing it before, especially in the absence of evidence that there was some meaningfully change to the site itself. So for example, if we got to day 4, day 5, and there was a change in image, and then you have evidence that the Deep Throat website may change over 4, 5, 6, 7 days, and then that will have to factor into that calculus, but they don't have anything that suggests that anything happened to Deep Throat during the course of Garcia's investigation other than what she testifies related to the payment address. And so I think that's why I understand why the state has to prove its claim, but that's why also I think the absence of evidence that Deep Throat did anything other than what they testified to is important, because it means that it's fair to assume that it was behaving the way that we have that was observed. It still maintained to do so, since there was nothing suggesting to the contrary. Excuse me.
What about the one image or one crime or 7 crimes?
So I think it should be looked at to what the images themselves display. So each image shows a distinct, different sex act involving different individuals. So even though it's listed as a banner, even though it's, kind of drawn up, you just got lines in between them and just one thing, each is a distinct sex act. And so when you have to come and indict a child pornography case and you use the images, one of the things that's part of the indictment in this case, well, what does the image show? Well, here's the sex act that it describes as prohibited, and so that's how you would charge it. So if you're looking at a specific image, well, what sex act are you describing? You pick one, you pick all 7, because they're all distinct and they're all different individuals. So they should be treated as separate images, because in practice they are.
What do you mean in practice they are?
I guess when I say it that way, so even though, the banner itself, you have just one block lines, and so when I say is, you could, on the way I understand defense argument, because it's one thing, it's essentially one image, just because they're all connected to each other. But even though
For
they're,
example, if it's a collage, and they're arguing that it's a collage, so therefore it's one image, could it have been clicked on, copied, and the entire thing moved?
I can't tell from the record, and I don't think they testified to it, but as the best I can tell, it does not appear to be that way. It appears to be, in terms of the image itself, one, in terms of if you were to download a file, that it would be one file. But I think in that instance, it should still be seen as 7, because it's a collage. It's a collage of different things. And so when we went back to charging it, we couldn't say, well, it has a collage of images, here's 7 different sex acts, but here's the prohibited sex acts for this, here's a prohibited sex act for this.
What about his intent? He clicked on a landing page. He had no idea how many might be on that landing page. To Justice Mez's point, what if there were 1,000 points on that, but he clicked once? And we don't have any proof that he went further.
So that in this particular instance, are you asking if the banner was 1,000 images? I think ultimately the Bitcoin transaction is more significant than defense argues in this particular case, because the Bitcoin transaction is evidence of that intent. And if the landing page had 1,000 different images, I think that in that situation, you could use any of the 1,000 different images, because again, they're separate, distinct sex acts involving separate individuals. But as far as the intent itself, the most fundamental reason someone would spend money at a website is because they want what it is offering. And that would include, if you're going on a banner page, which is advertising what may lay in, you're interested in both what it's the landing page is showing you and what's behind it, because if you're wanting what's behind it based on the advertisement, it makes little sense to me in any event that you would want one, but not, you tend to want one, but not the other.
And he clicked on the landing page after he paid. Is that right?
I'm not, I don't think that's quite what he testified. What I understand the testimony to, and I apologize if I was to get this wrong, but my reading of his testimony is that he was clicking on links into the hidden wiki, clicked on a link, it sent him to the page, and that's when he went the transaction to. Because if you look at the images, particularly States Exhibit number 1, you come in and you see what he describes when he's describing the page itself. They forget if it's a waiting payment or pending payment. And so in the States Exhibit, when you see the block where it says those words, the Bitcoin, and to know that and to see that, you would have to be on the page itself. You couldn't, well, Joshua Carr briefly says that it might be conceivably possible that you could somehow send Bitcoin to something, a web page, without seeing it. That's just not typically how this functions. Like, you'd have to know at that point the Bit wallet address to put in your app to submit the payment. So without clicking on the link to go to the site, especially if the allegation, well, the testimony is he didn't know what it was before he went in, he would not be able to have the wallet address unless somebody gave it to him, unless he went to the landing page before he submitted the payment. So in this case, I think the jury could easily reasonably conclude, even based on his own testimony, just how internet searching works, that to get to the point where you can submit Bitcoin to the site, you had to hit the landing page first, because there's not a lot of conceivable ways to have the requisite information to be able to make the payment in the first place without even being there. So
along those lines, if on the day that he made the Bitcoin payment, there was no images, is he still guilty of access with intent to view?
Of the underlying, if there's no images on the page itself, I think as the overlying crime was just outright possession of child pornography, no. I think in that instance, you would have something closer to attempt.
Just based on the Bitcoin transaction?
Yes, I think in this instance, yes, because the Bitcoin transaction is, again, the fundamental reason you send Bitcoin, you send money to anything, is because you want something in exchange for that. So he testified that his reason for sending it was to see how the website worked. The jury was free to disbelieve that or not, but because fundamentally, I'm not sure what that would teach anybody. But more to the basic point is ultimately that why else would you be sending it money? Fundamentally, from the jury's perspective, why I go to Amazon.com, I'm not going to send it money just because I want that item I purchased, or if I go to, I want that membership. So obviously, I'm sending it for a specific reason to get something in return. So I think in that case, if you go to a site, there's no images, but the website is clear enough that what it is offering is child pornography, even if the images were not present. I think under those circumstances, what you would have is an attempt case, because what that would show is you were attempting to access child pornography. Just a lack of images then would show you just didn't obtain that.
Thank you.
Since I don't get a rebuttal, if I may, I want to just briefly cover something. I anticipate that she's going to cover some of the Confrontation Clause stuff. Just to move in that just real briefly, the state's fundamental position, and ultimately outlined in its brief, is the state ultimately was boxed in and had very little options for it at the time that they had asked for it. Fundamentally, under 2he in the Code of Federal Regulations, the federal government has the absolute power to tell the state to essentially, when it comes to its witnesses, its evidence, to pound sand. If it doesn't want, so if it says, I'm not going to make this witness available, it can't then turn around and subpoena them to come in, because that attempt's going to immediately be turned around, removed to federal court, and ultimately quashed. It just simply cannot compel their presence or even to their testimony if the federal government will not allow it. In the Code of Federal Regulations is actually, in a sense, written in the reverse. It's not a situation where you're allowed to testify unless we tell you no. The CFR regulation governing HSI is the reverse of that, in that it says you cannot do it unless you are otherwise authorized. So if the federal government says, well, we'll make this a witness available to you, but this only under these conditions, the state really has no means of contesting that in any capacity. And this case goes even a bit further than the federal government just doing that. So Garcia was unavailable at the first trial setting, and so that was part of the reason state sought a continuance, which was granted, which appeared to be over objection. So they come to the next trial setting 3 to 4 months later. Garcia is again unavailable.
Mr. Eaton, are you saying that we are to find that any time the state says TUI, that we find a necessity to override the confrontation right? Is that what you're asking us to do?
I think that by itself wouldn't be necessarily.
That was the basis in this case. That was the finding.
It was part. It was part of it. It was the fundamental reason the state that asked for the Zoom testimony, because that is what the federal government ultimately would allow. But I don't think that's the end of the analysis. If the state had just said, okay, and hung up its hat and walked away and just asked for it and tried to make no other accommodations, I think it becomes a much closer case. But it had tried to continue it once at the first trial setting. At the second trial setting, she was again unavailable. It was going to try to make a substitute witness. And when at that hearing, Mr. Fisher had said, we're ready to go on Monday. The trial court defense objected to that in part, at least part because of substitution, but in part because they appeared to want Garcia specifically. And the trial court then turns and basically tells the state it needs to get Garcia, then seems to reset the case of its own accord, because neither Mr. Fisher or Norma Response actually asked for it. So it appears the trial court just simply chose to do it because defense really wanted Garcia present. So it essentially tried to proceed without her. So then you come to the actual trial date. It's being told at the announcement hearing for the trial, it's basically try or dismiss. So it's so it tried to make the accommodation of seeking a reset, and they could have moved for another continuance again, but all the trial court signals by that point are probably not going to grant it, and there's no guarantee that they'd have done anything different than they did. It tried to proceed without her, but was effectively denied the ability to do that. And so it was left with very little recourse. It suddenly can't contest the determination, so it either has to bring her in via Zoom or or at least from its perspective, fear that the trial court's just going to then turn around and dismiss the case because it again does not have Garcia present, and therefore the trial court deemed it unready.
I know we're past your time, but I do have a question on that. Are you saying that it seems like you're arguing that the inconvenience to the state or the inability to present the witness in present testimony should somehow change the constitutional rights of the defendant?
I don't think so. In the sense, I guess what I mean is, so under McCumber, it's like an overriding public interest. And I think the public interest ultimately in this case is going to be, there are times that the state is going to have to use federal witnesses, and this one we had to use a lot of them. And these witnesses can range anywhere from a very key witness to someone just tangentially involved in it. And so I think the calculus should be on this. The state shouldn't be punished or be unable to proceed when it's either got a key witness it can't do without, but is then boxed in by the federal government and has no reasonable alternatives available to it to try to move around that. And I think that's where we are in this case, is it tried to do other things besides Zoom testimony. Prior to that point was effectively shut down all of them. So when the feds decided we're only going to allow Zoom testimony, it had already been sent a bunch of signals from the trial court that the only options available to it to try to continue it, to move without her, it wasn't going to be allowed to do. And so the state shouldn't be pushed into, well, we're not just going to prosecute these, or we're just going to dismiss them off. The federal government does this, especially when we have the context of, well, we've tried to make accommodations and those aren't working either.
Okay. Any other questions? Thank you.
Thank you.
If it's okay, I think let's spend my first 5 minutes starting where Mr. Eaton ended and speaking about the confrontation issue. I'll respectfully disagree with his assessment of the trial court putting the state in a position that it was going to dismiss the case. There is the citations in the state's brief, I think were 6 RR 10 and 7 RR 11. And both of those citations do not support the assertion that was made on page 28 of of the state's brief, which was that the trial court reset this case despite the state not asking for it, and later confirmed that the August 26 trial date was going to be trial or dismiss. The judge didn't say that. What he did say, though, on the 8/19/24 setting, which I think is the supplemental volume, I'm not positive about that, but you'll be able to see it on the date. The trial court specifically said on page 9, you can go forward with or without Ms. Garcia. I want this case tried. The case wasn't getting dismissed. It was just going to be forced to go to trial. And I think that that's different than this position that the state is taking, which is we had no choice. We were going to get our case dismissed if we didn't do it the way the court was saying. And I just don't think the record supports that reading.
If we find it was error, how was it harmful?
So much of the sufficiency analysis that we've just talked about clearly focuses on the significance of Garcia's testimony and the inability for defense counsel, while they tried very hard and I think did the best they could under the circumstances, this was a really important witness to get to confront. There's pages of her testimony before they go on cross where they're trying to say, like, what files do I send her? How do we do this? Can she look at this page? You can.
Very messy, I saw that.
Yes, it was so messy. You can literally feel the chaos. And just because trial counsel did the best they could under a really difficult situation, I don't think that means it was harmless. I think they did the best they could, but I think you can see, even though I know you have to assume that cross-examination was fully realized for the purpose of the analysis, I think the harm considerations all weigh in favor of harm. And I think, again, the extensive discussion we've had about the importance, and I think in our brief we said her testimony was foundational to the case, and I think it was. And I just don't think that the jury really got to watch this witness be cross-examined in the manner that the client was entitled to under the Sixth Amendment. I had one more point on. Well, I'll come back to that. I don't want to waste time. Kind of circling back to some of the issues on sufficiency, is, if it's okay, may I transition back? Thank you so much. Talking about this 3-day window. So I went back and I just looked at Agent Garcia's testimony, and I think it's at 10 RR 88, if I can read my own notes, where she is specifically asked, what date did you access the site? And she gives one date. There's no testimony about anything done on the 9th. And then the testimony about the attempted payment on the 10th, I don't think is very clear about whether that attempt was made by visiting the site.
He said there was another witness that talked about the 10th. So putting those two witnesses together, you get 3 days.
Talking about Agent Croft. Yes, ma'am. Yes, ma'am. But forgive me, let me try and say this clearer. I don't think the day where the attempted payment was testified to means that in order to have attempted to make payment, that they revisited the site to do so. They had recorded the site on the 8th, so they had a way to go and attempt payment without making a subsequent visit. And I don't think it's very clear that when they tried to copy what they think my client did, I don't think that that implies there was a second visit. I think the clearest reading of the record is there was one visit. And I just don't think that that is enough.
Going to his intent.
Yes, ma'am.
When he paid a premium, didn't that membership allow him access to multiple, plural, in terms of images and videos?
I don't think we know that.
Isn't it on the exhibit itself? It describes what he got for premium?
Oh, talking about what the membership advertised for? Yes, ma'am. The membership under those two options did advertise for a variety of mediums. I think it was video and photos.
So from there, I think we could deduce that he had an intent to see more than one, and the only question is, did he actually see more than one?
I understand, I follow what you're saying. I'm going to respectfully disagree because I still think there is this unproven to the burden required that because he made the payment, that means he went to the site. And I would ask the court to focus on page 76 and 77 of his testimony. And he doesn't, I think that's where he is most clear. I don't recall seeing the top of the splash page. This click happened after I clicked on a bunch of other links. Half of them opened, half of them didn't. So what I read him to be saying is the payment information came from the hidden wiki indexes, not because he was transported to the site. And I think that that is a leap that the state is asking to make, that because he made the transaction means he went to the site, and I don't think we know that.
Didn't he describe the exhibit when he testified, the landing page, the deep throat? Didn't he describe it? Your client?
The citations where the state said that in their brief, I think in my reply I addressed that in all the ways I could conceive of where that came from, and no ma'am, he did not. He did not. If the court wants me to respond to a particular section where that's a concern, and I know exactly where in the state's brief you're getting that from, but I think in our reply, we address hopefully thoroughly that that is just an inaccurate reading of his testimony, and he did not do that. I've got 2 minutes left. Justice Brissett, you had talked about sequence with Mr. Eaton. Did he click on the landing, did I hear that right? Clicked on the landing page before, was it before or after the payment? I think maybe you were asking about after. And I just wanted to clarify, I don't think that there is anything that indicates payment, then landing page. I don't think that that is a sequence that can be reasonably inferred for the reasons we just talked about. And if the court,
What are you asking the court to do?
I'm asking you to please render judgments of acquittal on all 7 counts.
Thank you.
Yes, ma'am. I'll return the time to the court.
Thank you. The case is considered submitted and a decision will be forthcoming. Appreciate it.
All rise.